Thank you very much, dear Laszlo, for your very kind words of introduction. First of all, please allow me to express my sorrow over the fact that I cannot be with you in person today, as I would have loved to be here and talk to you face to face. I think we can start from the fact that everything we think about law is actually a collection of different points of view. Lawyers and international and national legal orders have changed through a variety of mechanisms. We no more think in a pyramid pattern. I believe that what we live through today cannot be placed in an empire-based order or a national order. So the structure and theory of liberal democracy has greatly changed as a result. Because in the countries where there is democracy, there are state structures in place that I believe lead back to a shared root with the state as such. If we look at the European Union, we can take note of a host of different characteristics. First of all, we must say that the European Union originally started off as an economic cooperation scheme that was extended by a host of new topics that traditionally formed the core of sovereign states and part of our constitutional identity. So when we discuss what it is we need to do if we want to give a constitutional charter to the European Union or want to create various constitutional narratives, then we can clearly see that it's the European integration process that truly goes ahead, and that ideological process changed the nature of the European plan to the core, meaning that nation states were forced into a defense logic because they felt that their sovereign areas were being gradually violated. We could quote the Brexit here, or the Russian constitution, which proclaims that national rights stand above any rules, for example, rules set by the European Court of Human Rights, and they even stand above the migration policy of the European Union. So we can see that in certain areas there is strong resistance. Let's see what happens, for example, in terms of national judges, who often perceive that national identity is a functional motion that limits European space or room for interaction. The judgment of the European Court passed on the 25th of June is of high relevance here because, to some extent, it serves as an obstacle to the supranational nature of European rulings. Sovereignty as such cannot be divided by its essence. So an interesting question arises as to how the coexistence of nation states can work with the European Union. We can see significant changes. And if we start from the position of judges, what is it that we see? The principle of sharing power has evolved in a different way. So it's based on the assumption that the political sphere has supremacy, and it's judges that determine how they can actually rule. So what we can see is that powers are shifting from politicians to judges. Basic decisions are passed by judges. So increasingly we see that social life is also regulated increasingly by judges, starting from the judicial and legal branches of power. This is a process that brings into question certain components of national identity. For example, if a judge declares that there must be proportionality observed, then we often see that that's not the case in reality. Quite often it's up to the judge to determine where the balance of power is. So if there is no hierarchy, or there are too many levels of hierarchy built up on each other, which essentially lead to the same status, then that essentially means that there are several legal systems in place, and it's the judge that will try and directly determine the structures that are imposed on politics. And if we want to be realistic and approach this process from a practical point of view, we can say that when we speak of European integration, human rights are also essentially creations of individual courts. So in that respect, yes, we can truly speak of the federalism of judges, as it's the judges themselves that create these systems and regulate these systems and the conditions that prevail between these systems. And therefore, it's a very important development that the power of judges has gained in relevance compared to the powers of politicians. So therefore, if we see that, for example, there is a conflict between Germany and the European Union as to the economic regulations they want to see in place, and the German Constitutional Code doesn't accept it, then that creates an incredibly interesting scenario, because the conflict essentially is between the German Constitutional Court and the European Court, and not between different political powers. So what is it that happens in these cases? Quite often, the hardcore of national identity seems to take supremacy over European powers. So quite often, the conflict is handed to the judges, essentially. Contrary to this, quite often, political power turns out to be too weak, which means that when we have the impression that national identities go through various crises, we must ask the question as to where this all comes from. When we speak of European identity, what we actually see is that it's a crisis of political power. That's the starting point. And speaking of conflicts that cannot be resolved through jurisdiction, staying on this path promises nothing good. Well, for Europe, it's a dangerous path. We have never had to face these kind of issues economic, geopolitical, financial issues. So we need to think about how we can actually reform this European software. How can we get to a stage where we don't need to deny national identity or turn inwards because it carries a lot of threats? So it's very important to build the Europe of nations for the future, meaning that we must unite in the differences, in the diversity of Europe. At this stage, I wish to note, in defense of the judges, that judicial power could gain such importance because politicians refused to deal with certain issues. They didn't want to deal with them, and they conferred them to the judges. So it's very important to be able to identify what it is that nations states should be responsible for as opposed to the European Union. So we must think about that along two lines of thoughts. So first of all, we need to clearly define what the national powers are as opposed to the powers of the European Union, and we need to do some real thinking about what it is individual states want to contribute to the common cause. With this, I believe there will be less of a desire or less of a tendency from citizens to think that the European Union wants to regulate the day-to-day lives of citizens. We will be able to reduce the issues to specific issues of economic and financial matters. And when individual states think about law, we mustn't just think of the European Court of Justice, and we mustn't limit our responses to the practices of the European law of justice. So we are obliged to create a constructive, forward-looking dialogue, because what we see is that if we face conflicts like the conflict that pinned the German Constitutional Court against the European Court of Justice, then that's certainly a dead-end street. Well, one conceivable route is to create a kind of entity that would, so to say, bring together national and European courts and force them to do some joint thinking. It's very important for national judges and European judges to be able to think together. In France, we have the so-called Court of Conflicts, which contains a judge from the public administration domain and also a civil judge, and forces them to find a joint solution. So it would be very important to ensure that national politics and European politics should be well positioned to say the last word instead of judges. So it's very important to reinforce the role of national and European politicians. I think we need to redraw the rights that are given to the European Parliament. It's an essential issue because the Parliament is a democratic organ of the European Union. So there must be real political debate going on in there, not about just anything, but about topics that fall within the jurisdiction of the European Union. So I believe it's not necessary to discuss all issues. We really need only the core issues, the real issues to be discussed by the European Court. And in that respect, there are a number of solutions, and I could personally recommend some concerning, for example, the way we elect European MPs. Within the European Union, we could actually elect them based on the principle of proportionality. And this way, it would be an entirely different style of election. We would elect them from supranational lists. And that would be important because at the level of the Parliament of the European Union, we shouldn't be discussing national issues, but issues that fall in the jurisdiction of the European Union. That's what the responsibility of the European Parliament should be. And of course, we could rightfully be worried that this could take us down the path of European federalism. But I think there are two specific approaches that could quell this worry about federalism. We could have a two-chamber parliament. There could be a lower house representing citizens, a lower chamber. And in the upper chamber, we could represent individual states. It's also important to note that if we can precisely define the rights given to the European Parliament in advance, certain worries would disappear by themselves. We should, for example, place the issue of control over the European Commission in focus. For the Parliament, it's important to exercise parliamentary powers, while the Commission should only be responsible for execution. I believe we must also discuss the various mechanisms that are in place, and in that respect, it's essential for me to be able to redefine the rights and authorities of individual institutions. It's also important to have a redefinition of the rights between national courts and the European Court. We must actually live a real democratic life along the rights defined in the European Parliament. Thank you for your attention. Thank you, Bertrand. Your message was understood clearly. Well, these are extremely heavy and difficult issues, and I cannot really go into detail to answer your recommendations. Please allow me to make just one comment. I fully agree that there needs to be a dialogue at national and European level between the judges. But as for the establishment of new institutions, I'm not sure that would work, because then we would be going more towards centralization, which is something I'd like to avoid. I think if we were to create a new unit, and Mr. Weber also raised that idea, well, I would be very careful with that, because if we create a new institution at European level, we are practically centralizing power. And then I wouldn't want to create a scenario where, for example, the French constitution would be looked at judges from other countries. So I would be very careful with that. And as for the cross-national lists, I also have some reservations here, because people don't really know the European MPs. If you asked anyone in the street who the French European MP was, very few could give you an answer, and it's the same in Hungary. But if there is a transnational list, then we will have no way of knowing who our MP is at European level. So there are many open issues, and it's a topic that we need to discuss at length at the conference focusing on the future of Europe. I don't wish to start a debate here. It's just a remark on my part, but we will meet in person and we can continue the discussion.